1 minute until showtime.
Okay. I gotta make sure my volume is working. So we got to go here. Okay, volume is working. Screen share. Mic. Mic. Alright, cool.
Your show will go live in 5 seconds. 4, 3, 2, 1. Blog Talk Radio.
Alright, good afternoon, everybody. How y'all doing? Give me 1 second, y'all. Let me get my phone. Where's my... I think I left it in the bathroom. All right, y'all. How is everybody doing? Good afternoon. It's been a minute since I've been live again, but I'm back. Been working on cases, y'all. All right. Before I get into the topic tonight, I want to talk about my case. When was it? This was a couple months ago, maybe 6-7 months ago or whatever. We filed the case. Well, I didn't file the case. A guy filed the case, state court. They filed a notice of removal from state court in federal court, so they moved it to federal court. And so once the guy got in contact with me, we talked on the phone or whatever, and he basically needed some help. Thank you. Yeah, but anyway, the guy needed some help, so I helped him out. Just helped him draft his complaint and everything like that. I'm not going to give you any names or where it happened at because the case is still being litigated. We're getting ready to work on an appeal right now. It's still being litigated, but YouTube is not receiving enough video to maintain smooth streaming. As such, viewers will experience open widget. I'm not sure what's wrong with it here. Let me see what's going on here. Yeah, I might have to restart it. Let me see. Your YouTube is not receiving enough. As such, viewers will experience buffering. Stream status says it's poor. Shouldn't be any problem with the streaming. Let me see how it's looking on my phone. I'm sorry, I gotta check it out. Give me a second, y'all. I gotta see how it's looking on my phone. I might have to end it and come on back. Okay, so now the signal is saying excellent. What's going on then? I don't know what's going on. To everybody watching, are y'all having any issues with the streaming? Because I'm getting a message back on my end saying that there's a streaming issue in regards to the quality of the video. So if you can hear me and if you're experiencing any issues, let me know. Put it in the comment section because I can't. I mean, I can't see it. I mean, I can't. Well, yeah, I can't see the footage. I'm looking on my phone right now. I'm trying to find it just to see if there's any streaming issues. Okay. I don't see any streaming issues on my end. I don't see any streaming issues on my end. Okay. All right. Well, I'm gonna start back and finish the story. Sorry about that, y'all. The reason why I did that was because I got a message back on my end saying that there was some streaming issues, so I had to check it out. All right. Back to what I was saying. So, a few months ago, a guy sued some police officers in state court, and they filed a notice of removal to federal court. I'm looking at the docket right now. They filed a notice of removal to state court. They paid the filing fee, whatever, civil cover sheet, all that. And so the guy contacted me. He needed some help. So I read over his paperwork, and I'm like, "You need to redraft this. This complaint needs to be done over." And so I assisted him. So the first thing we did was filed a motion for an extension of time, and we filed a motion for leave of court to amend the complaint. The motion for time was granted, and the motion for leave of court to amend the complaint. Um, it was I think he set it off for maybe a couple months or something like that. So they filed a motion to dismiss his first complaint. That's why I filed the motion for leave of court to amend the complaint, because in my opinion, the complaint needed to be redrafted. And so we redrafted the complaint. Their first motion to dismiss was denied after we redrafted the complaint. And then they asked for an extension of time some more. So all together they got around about 50 days or whatever to answer the complaint or to file a motion to dismiss. They never answered the complaint. Instead, they filed a motion to dismiss. All right. So, but when we filed the amended complaint, we requested the court to take judicial notice of the stenographic record of the proceedings that happened in the state court. The reason for that is because the guy won his state case. So this is what happened in the state case. I'm not going to go into too many details, but in the state case, they lied on the guy, y'all. They manufactured probable cause against him. They deliberately, and I'm not joking. I'm not exaggerating because I don't like the police and nothing like that. I'm serious. I've seen the evidence. They literally lied on this man and fabricated evidence against him. This cost him maybe fifty to $60,000 in litigation fees. These were 3 felonies. Um, and they lost at I think a motion to suppress here. And so the judge, essentially, the so-called judge in the state court, essentially held that they had no right to be at this guy's place. They had no right to search his place. Um, and the good faith exception did not apply also, because they tried to argue the good faith exception and that didn't even apply. So they tried to argue every exception to an unlawful seizure that they could, but it just wouldn't work. So all of the evidence was thrown out. Once the evidence was thrown out, the prosecution moved to null pros the case. In other words, they moved to dismiss the case. They didn't want to prosecute the case no more. All right. So once that happened, that's when the guy, about 2 years later, literally 2 years later, he filed his lawsuit, 42 Section 1983 lawsuit in state court. It was bad. They filed a notice of removal. Filed a notice. What was it? What did we file? Let me check this docket. I'm sorry, y'all. I'm all over the place. Give me a second, y'all. They filed a motion to dismiss. He contacted me. We filed a motion for an extension of time. Motion extension of time was granted. We amended the complaint. Their motion to dismiss was denied. They had additional maybe 30 days or so to answer the complaint. They never answered the complaint. Instead, they filed a motion to dismiss. In this particular amended complaint, like I said, we asked the court to take judicial notice of the stenographic record of all the proceedings in the state court. In other words, we wanted the judge to see what happened in the state court, and we were going to use all of that evidence, just to try to at least get it admitted into evidence right now before we can get actual witnesses to come in and testify about what happened. Nobody has testified in the case yet. So, um, once the amended complaint was filed and the answers, and their responses were filed, the judge issued an order, and he was going to take everything under consideration it was supposed to be the 2nd of this month. That's what we were waiting on. But a couple days ago, or maybe 2 weeks ago, 3 weeks ago, something like that, the judge issued an order. He moved back the date in order to hear the case or whatever. So he moved it back maybe 3 weeks or something like that. So we were waiting on the 3 weeks. A couple days ago, the guy called me. He called me on my cell phone, and he says, "Hey man, they dismissed the case." I said, "Yeah, I don't believe that." He said, "I'm serious. They dismissed the case." I said, "I don't believe that." He's serious, y'all. And I'm serious too, because ain't no way they dismissed that case. I know that complaint has merit. I know it does. Ain't no doubt in my mind about that. I'm 100% certain of that. It has merit. So he's still telling me, "Hey, man, they dismissed the case." I'm like, I don't believe that. Long story short, so I get online and I check the docket. And I go online and I see, like, he dismissed the case for real. He really did dismiss the case, y'all. So I get online and I read the order. All right. So I get online, I read the order. I'm like, this is crazy. So this is what happened. So we are when we filed the amended complaint and we requested the court to take judicial notice, you need to be very careful when you do that, because you're allowing a lot of hearsay to be admitted into the record. And it is hearsay within hearsay, probably within hearsay, because no witnesses are coming to testify in this case. So the evidence hasn't been properly admitted yet. We knew that. That's why we filed objections. So we filed all of these objections. These people did not respond to any objection, not one. They ignored all of the objections. All right, now don't get me wrong. They can ignore your objections. I would ignore your objections if they're meritless, but I do not file meritless objections. I don't file meritless lawsuits because I am not a vexatious litigant. I know what I'm doing. All right. So they ignored every objection, every single one of them. So I'm like, okay. So I read the order. The word objection is nowhere mentioned in the order one time. The judge ignored all of the objections, never ruled on them, never said if they were sustained or overruled. None of it. Just ignored all of that. Ignored every single objection. So I want to tell y'all my reason that I'm about I would say I'm about 100% sure of this. I'll be right back. Gotta go to the bathroom right quick. I'll be right back, y'all. All right. By the way, y'all hit that like button if y'all don't mind. Go ahead and hit that like button. Put them likes up. Hit that like button. All right. So this is the reason the judge dismissed the case. Excuse me, in my opinion. One, excuse me, we're pro se litigants. We're not supposed to come in here and we're not supposed to win. We're not supposed to follow the rules correctly and win, or almost correctly and win. You're not supposed to do that, especially against a bar attorney. You're not supposed to do that. All right, y'all. These people are haters. They hate it. And I'm not telling you what somebody told me. I'm telling you what I know based on my own personal experience, because that's how they do me. The other reason is this: the officers who they literally manufactured probable cause against this guy. All right, These officers are they were high-ranking officers then when this happened. All right, but now one of these officers, get this, y'all, this is gonna blow y'all. Y'all probably not even gonna be surprised though. One of these officers now is the chief of police. Yes, he is the chief of police. They promoted him to being the chief of police. So this is how serious this case is. It is extremely controversial because any complaint that these two officers touched is going to call in the integrity of all of their testimony, all of their police reports, all of their testimony at grand jury indictments, at trials. It's going to call into the integrity of all of these trials. So what I'm getting at is there are going to be a lot of people possibly come back and say, these guys lied on me too. And if these people get their convictions vacated, they can also sue these guys. It's going to cause just a domino effect, and it's going to cost that corporation a lot of money. And you crazy if you think they're going to let if you crazy if you think that they're going to let a pro se litigant do that and get that type of recognition. That's almost never going to happen. These people are haters. I actually told this guy, I said, man, I think if you would have had an attorney, I don't think this would have happened to you. But they just hate us. That's what they do. So the judge ignored every objection that we made, didn't even respond to them. The defense counsel ignored every single objection, didn't even respond to them. They don't want to talk about it. We made objections on hearsay grounds, lack of foundation, lack of firsthand personal knowledge, irrelevant, what is it? And lack of authenticity, because you don't have any witness to come in here and testify. So everything in your paperwork, until a witness with firsthand personal knowledge comes in and authenticates each of these documents, all of this stuff is irrelevant. It's not even properly before the court yet until it's properly admitted, unless we don't object, and we object. Because we're not trying to get the evidence admitted for the truth of the matter asserted within the documents. We're just trying to get them admitted for what they say. And if you're just trying to get them admitted just for that, that's not hearsay. They tried to get these documents admitted for the truth of the matter asserted within the documents. And you can't do that because you don't have a witness with firsthand personal knowledge to come in and authenticate these documents. Nobody has testified in this case. So therefore, that means there's no evidence before the court for the court to consider and make any of these rulings that he just made. That's what he did. He thinks we don't know that. Anyway, that's one thing I wanted to talk about. What is this? Y'all hit that like button, man. Get them likes up. Get them likes up. If y'all can hear me, put a 1 in the chat if y'all can hear me, because I'm not sure if anybody can hear everything that I'm saying. So put a 1 in the chat or just say something in the chat just to let me know that you still can hear me. All right, now I'm gonna get to the part where I'm talking about where I wanted to talk about when I was telling y'all what the name of the topic of the video tonight. This is our fault, and I'm gonna tell y'all exactly what I mean by that. If you have any, let me put the I forgot to put the call in number into the chat. Give me a second, y'all. Let's see. Okay, good. All right, thank y'all. Thank you. Y'all hit the like button. Get the likes up, please. Get the likes up. I put the call in number in the chat. If anybody has any questions, call in to the show. I got the call in number in. All right, let me see. There's a document. There's a case that I was reading. Is this it? No, this ain't it. Let me find it. This is a good case too. I want to read some of this document too. But I'm gonna get into the topic of the show um, tonight. I'm gonna give y'all this okay, let me see. I gotta find the date. There it is, right there. All right, I'm gonna do some screen sharing right now, y'all. So I'm gonna share my screen and I'm gonna show y'all this case as I read it to y'all. All right, and we gotta turn that off. Boom, there we go. All right, what is this? What is this thing doing? All right, all right. Let's see. All right, y'all should be able to see the screen right now. Let me go to the chat and just make sure that y'all can see the screen. Right here. Give me a second, y'all. I'm checking the chat just to make sure y'all can see the screen. All right, come on. And it's loading up right now. I'm trying to look at it from my phone right quick, y'all. I want to make sure that y'all are seeing the screen that I'm seeing because I'm doing screen share right now. Come on, come on. What is it doing? Hold on, y'all. Let me try it again. See if it's gonna work. Okay, good. Okay, I see it. All right, all right. Sorry about that, y'all. All right, look. Some of the stuff that I'm about to say, it may piss y'all off a little. And to be honest with you, I don't want to say it because I just the system like before I came to reading all of these cases and my understanding right now was just upset with the whole entire system and how it was being ran. You know what I'm saying? But now I'm not upset as I was. Like I understand now. So let me explain something to y'all. First, let me read this to y'all, and let me elaborate on what I want to talk about. When I say this is our fault, in regards to that, I mean like it's our fault that these public servants um are not being put in their place and reminded of who the sovereign is. That is our fault. Another reason why I say that is because I want y'all to see this. You see how old this case is? Let me make this a little bigger. You see how old this case is? This is June 23rd, 1898. A lot of these old cases, this is where your rights are. That's why you got to go and read these old cases. They're going to tell you everything that happened in the past so you can know what you're dealing with today. That's why I read the old cases. And this is a Nebraska case. It's a Nebraska case. The judiciary back then, based on me reading these cases from back then, I read a lot. And I haven't I need to read some more. You know what I'm saying? But it's just so many cases, y'all, for me to read. I just can't read them all by myself. But the judiciary back then, in my opinion, they did their job, y'all. Anytime your private rights was infringed upon and you acted upon it within a timely manner and you had the facts to justify the remedy that you were asking for, they gave you your remedy. They gave you your remedy. This case right here, this page, this thing is 61 pages. I think I read about 41 pages of it. But this is where your rights are. There's a lot of principles established in this case. So like the legislature they've been trying to do some of the stuff that they're trying to do today. They tried to do all this stuff 200-300 years ago, y'all. Let me show y'all. I'm gonna read some of this stuff for y'all, man. This stuff just blows me, y'all, when I read this stuff. I copied and pasted this the other day on my YouTube channel. This right here. If you go on my YouTube channel in the community section, you're gonna see this. You see all this stuff right here? What is this? Constitution 1866, Article 11, Section 6, Texas versus White, 7 Wall, U.S. All of these are cases. You need to go and read these cases, man. So let me read y'all something. The federal Constitution guarantees every state in the Union a Republican form of government. That's true because we have a republic. All right. The people are sovereign. That is true. A state with a different form of government could not be admitted into the Union. The right of local self-government is an essential element of a Republican government. So I want y'all to pay attention and listen to what is being expressly said and what's being implicitly said. Because if it's implicitly said, then it means the same thing as if it's expressly said. All right. So y'all need to understand it don't, for example, uh we have so many rights that are not even mentioned in the Constitution. But the fact that they're not mentioned in the Constitution expressly does not mean that they're not mentioned in the Constitution implicitly, is what I'm trying to say. Therefore, it is not within the power of the legislature to prevent the people of the city of Omaha from selecting their own officers. All right. This does not just mean in a democracy, this means in a republic too. So you have incorporated towns, meaning municipalities that have incorporated, meaning they have voluntarily made themselves subject to the territorial jurisdiction of the legislature. They had a right to do that, y'all. They owned the land. Nobody had a problem with it. That's what they wanted to do. All right. But when you do that, you're no longer in a republic. That is a democracy. And they have every right to remain there indefinitely if they want to, just like you have every right to remain in a republic indefinitely if you want to, and all you can do is respect it. It ain't nothing you can do. You can't wake them up. It's just ain't nothing you can do. It's there's too many rights. There's too many rights and equities involved in that in order for the matter to be adjudicated in a manner that's just and proper, in my opinion, because that's what they're trying to do. They always try to balance, based on me reading these cases. They always try to balance the rights and equities. Let me go down some more. The statute interfering with the right of local self-government in the city of Omaha is a violation of the following provision of the federal Constitution. No state shall make or enforce any law which shall abridge the privileges of or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the law. That sounds like the 14th Amendment and the 14th Amendment due process clause. That's what it sounds like to me. Local self-government is an inalienable right, whether wholly written, partly reserved, or wholly reserved. These are all the authorities right here, y'all. All this stuff right here. And I pay attention because they're citing so many cases that are not Nebraska cases because these are principles that they're talking about. Let me go down. I'm gonna go down some more. All right. I'm not gonna read all of this. I'm gonna read some of it. I'm trying to pick out the points that are important that I want to talk about. And then I'm going to elaborate on why I say this is our fault. Because if you go, man, look, these people should not have gotten away with what they're getting away with because the rights are already established. They've been established for at least the last 200 or 300 years and not reading. At the time of the Declaration of Independence, the town and the county were the only municipalities known to our political history, and they possessed complete powers of government in all local matters, legislative as well as executive. That's because it's an administrative agency. Any diminution of the original complete governmental powers of the towns or the counties arose solely from the voluntary surrender. I gotta read that to y'all again, man. I gotta read this again, man. I gotta read it again, man. Any diminution of the original complete governmental powers of the towns or counties arose solely from the voluntary surrender of their rights for the purpose of combining under a common government, which should be so constituted as to act as an agent for all in all matters of common interest. Powers not surrendered in the written constitutions remain with the people. The right of local self-government is the possession of the individual citizen. It does not belong to the states, nor to the towns, counties, nor cities, but to the men who inhabit them, in which respect it differs from the similar right to exercise, let me say right exercised by European municipalities prior to the revolution. Let me go back down. Sorry about that, y'all. It is an inherent right. It is conferred by no sovereign power, and no sovereign power can take it away. Do y'all hear that? Did y'all hear that? It ain't come from them. It ain't even come from you. It came from God. It is as common and an equal right. It belongs to every American citizen. I don't think I've seen them use U.S. citizen in here, other than another case citation. And a state constitution which should preserve it to some of its citizens and take it away from others would not be in that respect conform to the requirements of a republican form of government. Let me go down. I'm trying to. Hopefully I'll find this citation I'm looking for. Uh, where is it at? It is a vital, substantial right and no mere detail of government to be adopted or rejected at the will of the legislature. And there's the citations. Let's go down. If you want to know about municipal corporations, this is what you need to read. This is the authorities right here. One deal in municipal corporations. That is one authority with all of the principles of municipalities, municipal corporations, right there. This is from 1829 or 35, something like that. They've been had this stuff, y'all. Let me see if I can find it. Legislative enactments attempting to confer upon the governor power to appoint members of the board of the fire and police commissioners of the city of Omaha are unconstitutional and void. It is not within the power of the legislature to take from the people of municipalities the right of local self-government. You have a right to choose how you want to be governed. All right, so what they saying is this. Let me go back up. This is the part right here that I want to point out. Any diminution of the original complete governmental powers of the towns or counties arose solely from the voluntary surrender of their rights for the purpose of combining under a common government. That's a democracy, y'all. That's a municipality. That's a town. That's a city. That's a county. So in other words, when you come into a municipality, your sovereignty is limited because everybody within that municipality cannot exercise plenary power. It'll be chaos. So you have to limit some of your fundamental rights when you're in there. If you want to exercise plenary power, you need to move out of the municipality, out of the town, out of the county, or whatever you want to call it. Not out of the county. You have to move in a rural area. And if you're going to if you want to remove yourself from their within their corporate territorial jurisdiction, this case is going to talk about that too. You cannot sleep on your rights. And I'm gonna give y'all a hint because there was another case that I read, and I want to say that they're right. So let's say that you're in a rural area or somewhere like that, and you're paying property tax, all right? But a tax based on the cases that I've read, there's no citation that says this expressly. It just says it implicitly, okay? A a tax is conditioned upon a benefit. All right. So in exchange for this tax, what benefit am I getting? So if you're paying these people, but they're not giving you any benefits, that is inequitable. All right. That's an iniquity. That is contrary to equity unless you consent to it, you okay to it, you acquiescence to it. So what I'm trying to tell you is you can petition for a writ of quo warranto to oust them from exercising their corporate territorial jurisdiction over your land because they're not investing in the land at all. They're just taxing you. So in other words, when you think about it, they have essentially taken your land for public use without just compensation, even though they're not using the land. They're just taxing you. You can't tax private property. You can't tax rights. You're only taxed on benefits and privileges. A license is a tax. It don't have to be called a tax in order for it to be a tax, but a license is a tax. Y'all make sure y'all hit that like button. Hit that like button. Also, I'm gonna be saying this throughout the show tonight. Um, if y'all don't mind, because I do like to get paid for my time, um, I want to get my juror members up, my monthly subscribers for my juror members. So if y'all don't mind, I would really appreciate it if everybody watching, if you haven't already, joined the juror members subscription. I think it's $1.99 a month, something like that. I would really appreciate that. Um, that would funds will help me just focus on this because I have, like I said, we all have bills to pay. You know what I'm saying? But if y'all want me to keep doing stuff like this, I'm gonna have to get compensated for it, so I don't have to focus on anything else except this, because I know how to find the cases, and I can do this all day. This is easy. I can't read them all, but this is easy. But let me go down a little bit more, y'all. Let's go down. Um, where are we at? I'm trying to let me see. Um, let me go back. I gotta make sure I ain't getting no. I gotta check and see if I'm getting any questions. Give me a second, y'all. I'm trying to find this quotation that I'm looking for. Let me go down. I think it's gonna start talking about some of it down. It's probably I'm gonna read this. I think it's gonna start talking about it down here. But let me check the chat right quick and see if we getting anything. Yeah, he gave a reason. SG. He man, look that he didn't really even cite any of the complaint that we drafted. That complaint, I know that complaint is flawless because I draft that complaint. I know that complaint has merit because I read every single case for every single cause of action in that complaint. And there was, in my opinion, there's only maybe about 5 to 6 out of probably about 40, I would say about 40 to 50, maybe 60 causes of actions in that complaint. I know that complaint got merit. I know it do. So this was one of their. I'll talk about that a little bit. I'll talk about that a little bit. Um, so one of their reasons was they were saying that the complaint is barred by statutes of limitations because the guy, this happened in 2017. All right, but we were litigating. He was litigating the case in state court for like 4 or 5 years, and they didn't null pros the case until like 4 or 5 years later. So 2020 was it was 2017 when it started. I think they null pros the case in 2021, and the guy filed the lawsuit exactly 2 years later. He filed it on the last day within the statute of limitations that it had to be filed. So he filed it within time. All right, but they're saying that the cause. I mean, they're saying that his time started on his malicious prosecution and Fourth Amendment claims or whatever. They're saying it started on the day that he was released from custody, and that ain't true because a cause of action does not accrue until all of the elements are there. If you sue them and you don't have all of the if you sue them and you don't have all of the elements, then your claim is unripe. It's premature. It's not ready. All right. So the final element that we needed to sue them was the prosecution had to terminate in his favor, and it did when they null pros the case. So when they null pros the case, that's when the statute of limitations starts. There's cases on that hold that, and we cited all of these cases. I crossed all my T's and dotted all my I's, and they ain't see. They just did this and filed their paperwork. They act like they ain't see nothing. They act like they ain't see nothing. So let me go to the phone lines. I'm sorry, y'all, I forgot. All right, no phone calls yet. So yeah, they just act like they didn't see nothing. So the judge, let me do y'all want me to read it? I'll read some of it. Let me go to it. I'm gonna pull the order up and go to it. Where is it at? Right here. I'm gonna read some. I'm not gonna read all of it. I mean, and then it ain't number 6 pages. 6 pages. The words are small and they all bunched up together. Now this man did not. The word objection is not used anywhere in his order. Nowhere in his order. They can, like I said earlier, they can ignore your objections if they are meritless. They can. I don't file meritless objections though, because I don't file meritless lawsuits. I'm not a vexatious litigant. I know what I'm doing, and if I don't, I'm gonna go read cases that's gonna tell me either expressly or implicitly what to do. Let me see. Where are we at? Let me go to. I'm gonna go and read you the Fourth Amendment violations because we had so many of. We had so many of them. Now, just this is just to let y'all know. I don't care if it's. I don't care if it's 100 years. All right. If you're in prison and you get your conviction vacated because they fabricated evidence against you, you can sue them. I don't care if it's 100 years later, because you can't sue them until the conviction is vacated in your favor or the prosecution terminates in your favor. Then you can sue them. The reason why you can't sue them is because they, what do they call it? What's that term? I think it comedy is one of them, and then I think there's a full faith and credit um involved in one of them. So it's like the feds, they don't want to step on the state's toes in regards to the cases that are adjudicated in state court. In other words, they don't really want to reverse the conviction, and they have to abstain from it. I think it's called the Rookerfield doctrine or something like that. They have to abstain from it. Did you ask for a response to the GE objections, like Yusuf said? We didn't. We never went to court. We was he was supposed to go to court 2 weeks from now. That man? He randomly did this. We thought we were going to go to court. This was so random because he's supposed to go to court on the 26th. He just randomly did this and dismissed the case. But yeah, I know what you're talking about. You're talking about an equivocal rule. Yeah, he needs to substantiate these objections. Don't ignore it. But see, he don't think we know this stuff though. So we getting ready to file an appeal and all that stuff. But let me get down to the Fourth Amendment claims. All right, Fourth Amendment and due process. The court begins with plaintiff's Fourth Amendment claims. The plaintiff alleges that the defendant officers violated his due process rights by unlawfully detaining him, seizing his property, and fabricating evidence. The defendants argued that counts 13 and 14 should be dismissed because plaintiff's remedy lies in the Fourth Amendment, and count 21 should be dismissed because plaintiff cannot plausibly allege a deprivation of due process. It is well established that a substantive due process claim may not be maintained where a specific constitutional provision protects the rights at issue. I already know all this stuff, but I'll read it for y'all if y'all want me to. It says, I'm gonna take it off screen share for right now. Let me take it off screen share. All right, sorry about that. I assume the complaint from malicious prosecution was timely, right? Yeah, everything was timely. Every cause of action that I had in that complaint, except for maybe about 5 or 6 of them. But I don't care about those 5 or 6. I care about the 40 to maybe 50, maybe 60 of them. They were timely. I know they were timely because I read the cases and they were timely. Let me go down. Let me see. Here we go right here. Now this man, y'all, this man do not cite. Look, man, when anytime somebody files a motion to dismiss, all of the facts have to be taken as true, and every reasonable inference has to be drawn in your favor. He didn't do none of that. That man ain't do none of that, man. None of it. In count 21, the plaintiff alleges a due process violation on the defendant's use of fabricated evidence to pursue his prosecution. The court notes that unlike wrongful pretrial detention claims based on fabrication of evidence, let me see, based on fabricated evidence, fabricated based wrongful conviction claims implicate due process. Convictions premised on deliberate fabrication of evidence will always violate the defendant's due process rights. This case, however, does not involve a conviction. No, it doesn't. Rather, the plaintiff alleges that he was released 5 days after his arrest and the criminal charges against him were later dismissed. The plaintiff's evidence fabrication claim thus does not arise under the 14th Amendment. They right there. It doesn't rise under the 14th Amendment. Explaining the due process clause was inapplicable because the plaintiff did not raise a claim of wrongful conviction. That's because he wasn't convicted. Instead, as will be discussed below, the appropriate vehicle for plaintiff's fabrication of evidence is the Fourth Amendment, and they write about that. All right, so we got Fourth Amendment unlawful seizure, and let me see, unlawful search and seizure. Next, plaintiff alleges that the defendants unlawfully searched his person and home and seized his property without probable cause in violation of the Fourth Amendment. The defendant contends that these claims must be dismissed as time barred. That is patently false because he filed that within the statute of limitations. All of the cases that we cited in support of our arguments, they ignored them. They don't want to talk about it. And I know I've been litigating cases for a while, y'all. When you wrong, they might drag their feet a little bit, but they love to tell you when you wrong. They love to tell you when you wrong. And they gonna do it on the public record because you're a pro se litigant. But you out your minds if you think that they gonna tell you, a pro se litigant, that you right against a multi-million-dollar law firm of 7 to probably 9 attorneys. I don't know how many attorneys at that law firm. That little old you is right and all 9 of them is wrong. You think they finna do that? Come on, man. While a plaintiff need not anticipate and plead around affirmative defenses in the complaint, the statute of limitations may be raised in a motion to dismiss if the allegations of the complaint itself set forth everything necessary to satisfy the affirmative defenses. The plaintiff's Fourth Amendment claims are governed, statute of limitations, which is 2 years. All right. I read a case not too long ago, y'all. It happened in like the 70s or 80s. This guy got his conviction vacated because they forced him into pleading guilty or something like that. He got his conviction vacated and he sued them. And they said he didn't file it outside the statute of limitations. They said it was timely. How you file a case almost 30, 40 years later and it's timely, but we can't file ours 2 years later on the last day and it be timely? And this is the same state, this federal law. It's a 42 section 1983 case. Y'all hit that like button. Also, man, y'all do me a favor and go ahead and sign up for that jury members. I think it's $1.99 a month. $1.99 a month. Y'all go ahead and register that and sign up for that. I really appreciate it. Let me go. All right, here we go. Here, the First Amendment complaint alleges that the unlawful search and seizure occurred in 2017. The plaintiff, however, did not file his initial complaint until 2023. What are they talking about? It looks like it looked like he intentionally put the wrong date in here. Let me see. The search and seizure on January. The plaintiff, however, did not file his initial complaint. He got the wrong date in here. Think he do. I have to go back and look. The plaintiff's argument that he was precluded from bringing his claim under Heck, blah blah blah, is unavailing. Let me see. This guy. No, that's right, because his case wasn't terminated until like June 2021. The plaintiff's argument that he was precluded from bringing his claim under Heck v. Humphrey is unavailing. And then he cites this. Many claims that concern how police conduct searches or arrests are compatible with conviction. What does that even mean? What does that have to do with us saying that our claims are foreclosed until we get either the conviction overturned or we get the prosecution um, dismissed in our favor? That don't have nothing to do with that. How long you been? He used to be a prosecutor. This so-called judge. He used to be a prosecutor too. What is that? That don't have anything to do with it. So we're gonna go to the malicious prosecution claim next, SG. Let me show you what I'm talking about. The Fourth Amendment, unlawful detention and malicious prosecution. The plaintiff also invokes the Fourth Amendment to assert unlawful detention and malicious prosecution claim based on fabrication of evidence. He alleges that the defendants fabricated the police reports, they did because I read them, and the affidavits, they did because I read them, to obtain a search warrant, and the grand jury testimony, they did because I read it, resulting in his unlawful detention and the commencement of criminal proceedings without probable cause. When I tell y'all they lied on this man, they lied. They deliberately, knowingly, and intentionally fabricated evidence against this man. Cost this man all his money, so-called money, and almost cost him his freedom. Allegations of wrongful arrest and detention and pursuit of charges without probable cause are actionable under the Fourth Amendment. Yeah, we already know that. Let's get down to the merits of it. I want you to notice that he's not really giving you a factual background. He's supposed to do that in his opinion. He's not really telling you what happened. He's just making conclusions. Let me see. A Fourth Amendment claim for malicious prosecution accrues when the underlying criminal prosecution is terminated without conviction. That's not just for malicious prosecution. That's for any fabrication of evidence claim. If you have a claim that's based on fabrication of evidence, you cannot pursue that claim until the conviction is overturned in your favor or the prosecution is not vacated, but is null pros or something like that. You can't do it. Let's go down here. Fourth Amendment claims where timeliness was measured from the plaintiff's release on bond rather than acquittal. No, it ain't. No, it ain't. There is thus no timeliness issue apparent from the face of the First Amendment complaint as to these claims. The question then is whether the plaintiff has plausibly alleged a Fourth Amendment malicious prosecution claim. To state such a claim, his allegations must at least show that the prosecution was initiated without probable cause. Yeah, we saying y'all fabricated evidence. That's what y'all did. Y'all didn't have no probable cause for that. If you had probable cause, then why did you manufacture it? If you had it. And end it without a conviction. Those are the only two elements right there for a malicious prosecution claim. We have these elements. The defendants argue that the plaintiff has pleaded himself out of court in light of the state court transcripts, the police reports, and the search warrant that he attached to his First Amendment complaint, which show that there existed probable cause for his arrest and resulting conviction. That's what he's saying. But we're telling you everything that happened in the state court was fabricated. So how could you reasonably come to this conclusion? Not only that, because we're disputing these facts. Anytime that you have facts, anytime that you have material facts that are in dispute, it goes to the jury for the jury to decide. Not you, unless we waive our right to a jury. So what are you talking about? As a threshold matter, the court can consider the documents attached to the plaintiff's amended complaint in ruling on a motion to dismiss. That's true. Yeah, you can do that. where a plaintiff attaches documents and relies upon the documents to form the basis for a claim or part of a claim, dismissal is appropriate if the documents negate the claim. I agree with all that. But you think you slick. You think we dumb. Come on, man. This man every argument that we made, he ignored. Why would you do that? If these claims were meritless, why would you do that? Let me see. The statute usually gives a time from the occurrence or from when it was discovered. Finish reading that please about the timely filing. What you mean? Let me check the phone lines. I'm sorry, y'all. Y'all can call in right now if you have any questions. Call in and we can talk about it. Just call. Let me put the call. I'm gonna put the number back in the chat and y'all call in. Excuse me. Who commits malicious prosecution? The attorney, the police. It was the police in here. We're not gonna worry. We didn't want to worry about the attorneys. We just wanted to make this real simple. Cause in actuality, it really was the police. They man, they literally lied on this man, man. I wasn't um I wasn't sure the extent of their fabrication of evidence until I actually like he showed me the evidence. I got it on my computer. He showed me the evidence. Took me a minute to get it, and I'm like, damn, they really they lied on this man, man, under oath in affidavits, in the police reports, at the grand jury testimony. They lied on this man. They lied on him. And if any man, look, this case is so controversial. They gonna have to vacate. They will probably have to vacate every conviction that these police officers touched in ever since they've been police officers at that police department. Not only that, one of them is a police chief. Now he's a police chief. The one who lied, he's a police chief. He got to go, man, because this is not their first time doing that. They've done that plenty of times. I don't know how many, but that is not their first time doing that. Lying is not illegal. Presumption and assumption are legal. Lying under oath or perjury is where it hurts. Judges and lawyers know that very well and play within. I agree with that. I agree with that. But they all right. Since you want to say that, we can do like this. They knowingly and intentionally misrepresented materially false inculpatory statements against this guy. That's what they did. That's exactly what they did. And lied about it. They say time is barred only if if they state a limit. Until then, some one time may be different than another. I'm gonna have to show y'all what I'm talking about. Cause he filed that within time. The reason why the reason why he filed it in time is because it's the nature of his cause of action. It's a fabricated evidence. All of our claims are fabrication of evidence claims. They are damn near all of them are fabrication of evidence claims. So anytime you bring a fabrication of evidence claim, uh, you cannot do it until either the conviction terminates in your favor. I mean, the conviction, you get it vacated in your favor, or the prosecution terminates in your favor. Then you can sue them for everything that they did to you. I don't care if it's a million years. They know that. But let me get back to this. Let's go back. Let's go back. Do y'all want me to continue reading, reading from this case a little bit? It's only like one more page. Or do y'all want me to get back to what I was saying about that this is our fault? Let's see. Are you talking about criminal cases? No, this is a civil case, Miss G. This is a civil case. Alco, did you get that email I sent you of that ebook, Miss G? Because I sent you an ebook probably like 2 weeks ago, maybe I don't really know how long ago, but I sent it. Hypothetically speaking, the judge said it wasn't malicious because they had an affidavit or a probable cause to arrest them. Let me go back and read it. Yeah, yeah, that's what the judge is saying. That's what the judge is saying. So he's saying all of the evidence that we filed in court or whatever, he's saying that shows probable cause. All right. But listen, this is what this is what people are missing. All right. Anytime you request the court to take judicial notice of something that happened somewhere else, that is hearsay. All right. Now, hearsay is admissible if it qualifies for a hearsay exception. All right. Or if you're trying to admit it, but not for the truth of the matter that is asserted within the documents. All right. Then it's admissible. All right. They are trying to admit all of these documents into court for the truth of the matter asserted therein without having witnesses to come in and lay a foundation to properly get this evidence admitted. That is what they did, and you cannot do that over an objection. You can't do that. Uh, if they ask you to fill out this paperwork but don't put a time limit on there, then it's a reasonable say I don't know what he's talking about. That's the issue. I'm gonna read this last little part, and then I'm gonna get back on the topic, y'all. Sorry about that. I'm gonna get back on the topic. As a threshold matter, the court can consider the documents attached to the plaintiff's First Amendment complaint in a ruling on a motion to dismiss. Where a plaintiff attaches documents and relies upon the documents to form the basis for a claim or part of a claim, dismissal is appropriate if the documents negate the claim. Such is the case here. This is what he's saying. Now, I want y'all to take into consideration, we filed objections. He ignored all of the objections. He don't want to talk about the objections. This is the judge now. Now, the judge did not. He's not the only one who ignored the objections. The opposing party also ignored the objections. All right. The basis for a plaintiff's malicious prosecution claim is that the defendants falsely reported that they observed one of the stolen wells. Not only that, one of the thing that they were saying that was stolen was never reported stolen. One of them that was reported, it was never reported stolen, and they couldn't identify the other items that were allegedly stolen either. But they said that they could, but they couldn't. When I got the evidence and they lied. They lied at the grand jury hearing. They lied at the motion to suppress hearing. They lied in the police reports. They lied in the affidavit. How you like? Come on, man. Anyway, in the plaintiff's garage, and this fabricated report was used to obtain a search warrant and pursue criminal charges against the plaintiff. He's misconstruing the facts also. The issue with these allegations, however, is that the documents attached to plaintiff's amended complaint show that the defendants investigating of a Facebook post advertising the stolen welders for sale led the officers to plaintiff's residence, where they observed what appeared to be one of the stolen welders from the window leading to the plaintiff's garage. This led to a more fulsome search pursuant to a warrant and ultimately the plaintiff's arrest after the defendants discovered the stolen items at his residence. The plaintiffs attached thus undermine and render implausible the plaintiff's allegation that his arrest and subsequent prosecution were not supported by probable cause. We're telling you, do y'all see how he ignores the fact that we're saying that they manufactured all of this evidence? He's ignoring that. He don't want to talk about that. He don't want to talk about it. The key to reality in this realm is form. We take form and become human. It's our fault because we keep filling out forms and giving form to their realm. But yeah, that's what he's doing. All right, let me get back to the topic. All right, I want to get back to the topic, and I want to stay too far off the topic. The number is in the chat. I'm gonna put the number in the chat again, and I'm respectfully asking y'all to go ahead and sign up for that jury membership. It's $199, $199 a month. I think I almost got like 2,000 subscribers, so I should have um, I should have at least 100 jury members. I think I only got like 5 or 6. So I'm respectfully asking y'all to sign up for that. We must liberate ourselves completely. That is our remedy. You're already free, so you're already free, man. Let's get back. Where's this document? All right, let me start back screen sharing, y'all, and then we'll jump right back into this. All right, so back to the topic. When I say this is our fault, this is our fault because I would say anywhere from 150 to maybe 300 years ago, all of our private rights were being established. All right, they're everywhere, y'all. Excuse me. Let me show y'all what I mean when I say that they're everywhere. Um, let's go here. We're going to case dot law. We're gonna go here, and let me show y'all what I'm talking about. They are everywhere. You're right. They're everywhere. So we're gonna say we will click. Let's go here. Is this it? Yeah. I'm gonna click that. All right. So I'm just gonna click on a random so-called state. What is this? Kansas. All right. So we're gonna click on Kansas. All right. See this? 1858 to 2016. That means the very first Kansas Supreme Court case is in there. This is the appellate court, 1895 to 1901. They there. Southwestern edition, 1920 to 1999. Look at this, Kentucky. This is probably the oldest one I've seen. Kentucky reports, the oldest Kentucky case. Let me go ahead and click on this. This is why I cannot do this all by myself, y'all. I need help. I cannot do this by myself. This is one volume, all right, from 1718 until 1951. This is one volume. Do y'all know how many cases in this volume? Let's see. Let's go and see. Let me show y'all. These are all the cases in this one volume. These are all cases. 1801. Let's see what the first case was about. Let's see. A caveat for 100 acres of land in Fayetteville. Okay, this one is short. All right, so that's a short case. Trying to find something that's kind of long. Now, the older cases like this, they are very short. They're very short. Um, I don't know. I don't wanna get too much off point. But anyway, these cases are extremely old. But this is where your rights are. They're in these cases right here. All these old cases, this is where your rights are. The judiciary did not fail us, in my opinion, based on the old cases that I was reading. The judiciary did not fail us. All right. But you don't know what your rights, so you have to go and read it. This is just one volume out of, look at this, 314. That is a lot of cases. I cannot read all those cases by myself. Let's see, view API. What's API? Okay, that ain't it. It's probably, no, that's not it either. Okay, I thought they were going to give me the whole thing. That's one volume, just one. Let's go to Kansas. Let's see how many Kansas got. If you're in Kansas, look at this, 1858, 304. This is one volume. It's probably 200, maybe 200 cases per volume. Or I don't know. I'm just guessing. Look at this. I cannot read all these cases by myself, but this is where your rights are. You need to go and read these old cases. The reason why I'm telling you to read these old cases is these cases um were being decided either before or after these municipal corporations made themselves subject to the corporate territorial jurisdiction of the legislature. That's why you need to go and read these cases. You got to go and read them. This is our fault. It is nobody's fault that you don't know your rights except you. Is that Patreon? I don't think so, SG. I don't think so. Uh, let's see. So let's get back. Where's that document at? Is this? I think this is it. Okay. In Von Holt's constitutional law, page 217, may be found this apposite language. Congress has the Congress has only the powers granted it by the federal constitution. The legislative power of the state legislatures, on the contrary, is unlimited as far as no limits are set to it by the federal or state constitution. This does not mean, however, that these restrictions must always be expressed in explicit words. It doesn't matter if it say it in there. If it says it implicitly, then it says it. It means the same thing as if it said expressly. It doesn't matter. As it is generally admitted that the factors of the federal government have certain implied powers, so it has never been disputed that the state legislatures are subject to implied restrictions. That is, restrictions which must be deduced from certain provisions of the federal or state constitution, or that arise from the political nature of the Union, from the genius of American public institutions. Judge Cooley, in his valuable work on constitutional limitations, 5th edition, page 203, used this language. If it does not follow, however, that in every case the courts before they can set aside a law as invalid, must be available to find in the Constitution some specific inhibition which has been disregarded, or some express command which has been disobeyed. Prohibitions are only important where they are in the nature of exceptions to a general grant of power. And if the authority to do and act has not been granted by the sovereign to its representatives, it cannot be necessary to prohibit its being done. Let's go down. Indeed, this right of local self-government, as it has been briefly termed, is held to be an established feature and incident of our political system. And it is not within the power of the legislature of a state to permanently fill by appointment the local offices established by law for purely local purposes. Let me see. I wish I could find that citation I'm looking for. Escape the detention. Point out numerous cases where the legislature might act as avoid transcending. I'm trying to find this case I'm looking for, y'all. Well, not this case, this citation I'm looking for. The Department of Government and individual citizens according to the spirit and intent of the framers as indicted by its terms, an act violating the true intent and meaning of the instrument, although not within the letter, is as much within the purview and effect of prohibition. Okay, that ain't it. I wish I had time to find this. I don't want to keep y'all waiting. Let me go back and check this out. No, that's not it. All right. Is this it? That's not it either. I lost the case. What a case at right here. All right. Let me see. Is this it? While the validity of the legislation is brought into question, it is not necessary to show that it falls appropriately within express written prohibitions contained in the Constitution. The implied restraints of the Constitution upon legislative power may be as effectual for its condemnation as the as the written words, and such restraints may be found either in the language employed or in the evident purpose which was in view, and the circumstances and historical events which led to the enactment of the particular provision as a part of the organic law. So, long story short, this was all about the legislature is trying to usurp an authority, a fundamental right, an inherent right of the people by trying to appoint administrative officers over their municipal corporation. All right, but the people want to do that themselves. They want to pick who they are chose to be governed by. They tried to do this over 150 years ago, y'all, and the judiciary said no, you can't do that because the people have a right to determine how they want to be governed, whether it be a democracy, meaning they come together in a community and they form a municipal corporation. They get a charter. They voluntarily make themselves subject to the corporate territorial jurisdiction of the legislature. They can do that if they want to. And there is nothing you can do about it except move if you don't like it. Because you don't own the land and you cannot, it's going to be very difficult for you to convince all of these people um, that this is not in their best interest. They have just as much as right to make that happen as you to make your own happen in the republic, meaning outside their corporate territorial jurisdiction. That's what it is. So essentially, what they've done is, if you live in an incorporated city, town, or county, whatever you want to call it, all right, that is a democracy. All right, because it's majority rule over there. Let me see if I can find that in this case. This was a long case, so that's probably why I'm having some difficulty finding it. Hold the legislature see fit to create a county office and should provide the general election. You probably got a birth. Let me see. The supreme power of the people does not. All right. This is a good citation too, so I want to read this one. I wish I could find what I'm really looking for. The supreme power of the people does not arise from the Constitution or exist by virtue of it. Let me read that again, because you had these rights before the Constitution, but your rights again, when you form a community, your rights are limited. And in my opinion, that is the just, fair, and proper thing to do, because everybody in one community cannot all exercise plenary power over that community. There will be chaos. You can't do that. So if you want to exercise plenary power, then you need to move and get to your own land and do what you want to do whenever you want to do. And when you move there, you need to send out notices, because I'm almost sure that that land in that rural area is going to be within their corporate territorial jurisdiction, and you need to send them some notice and tell them that you want to remove that from their jurisdiction. And I'm gonna read y'all a case that tells you why you need to do that. Because if you don't, and they start sending you money and fixing up that land, and it's a wrap. You're not going to be able to oust them from doing that unless you come to some agreement outside of court saying you're going to reimburse them for the cost that they've invested in the land and stuff like that. But anyway, the supreme power of the people does not arise from the Constitution or exist by virtue of it. It existed prior to it. It makes and unmakes constitutions, but it is not made by them. Consequently, we are not to look into the Constitution for any grant of power to the people. Did y'all hear that? Did y'all see that? This case is from 1820 something or 30 something. This is where your rights are. This is why I keep saying this. I'm gonna keep saying this all throughout. This is why I say this is our fault. This is our fault. I'm gonna go and tell y'all, I don't now, after reading these cases, I do not see anything wrong with people wanting to incorporate a municipal corporation. If they want to. I don't want to, but if they want to, they have a right to do that. The problem is the people within these municipal corporations, maybe the shareholders, because they do have shareholders, but maybe the shareholders or the high-ranking so-called political politicians or the rich people or whatever, they are greedy. The ones who are controlling everything, they are greedy. They're extremely greedy. That is the problem. And we all know power corrupts power. That is the problem. All right. But another part of the problem is you acquiescence in it. You don't do anything about it. All you do is go to court, plead guilty, and you pay a fine or something. That's not gonna stop. You're not helping the problem, because they're not gonna stop. They're not gonna stop. But anyway, consequently, we are not to look into the Constitution for any grant of power to the people or any definition of their powers. They possess all that they have not surrendered by the Constitution. One of the primary purposes for the adoption of a written constitution is the protection of minorities and individuals from the exercise of absolute power. For that purpose, the people have yielded, this is the citation I was looking for. For that purpose, the people have yielded up some of their powers, but they retain all that they have not restricted themselves from exercising by the express words of the Constitution or by necessary implication therefrom. When you go to a community, your sovereignty, your plenary is limited, and rightfully so. The Ohio legislature enacted that certain cities of the state should have a board of police commissioners to be elected by voters of the municipality, but that no elector should vote at an election for more than two persons for such commissioners, and the four persons receiving the highest number of votes should be declared elected. Where is it at? This is one right here too. This is Nebraska, 41 edition, blah blah blah. Lowe versus Riz. Let me see. Held that an act. I want y'all to pay attention to this. An act known as the 8-hour law, invalid on the ground that it denied the right of the parties to contract without reference to compensation for services. Although no express constitutional provision guaranteed to the individual the right to contract as he pleased, the law was also held bad as class legislation, but the decision was placed as squarely upon other ground. It was, let me see, what is this? West Point Power Land Improvement. It was ruled that the reserved powers of the state are inalienable and cannot be surrendered or taken away by the legislature. You need to know what your rights are, man. You got to read these cases. So I'm not sure if I said this earlier, but you have every right to move in a rural area outside the corporate territorial jurisdiction of the legislature, which is the republic. That is where your plenary power is. In the rural area, it's your land. You do what you want. It's private property. You do what you want. You have every right to do that. The first article of our state constitution expressly enumerates certain rights which people have reserved to themselves, and manifestly any law passed in violation of such reserved rights would be declared by the courts unconstitutional. It cannot be successfully asserted that the only rights reserved to the people are those enumerated in said article of the Constitution, since Section 26 thereof declares, this enumeration of rights shall not be construed to impair or deny others what? Other rights retained by the people, and all powers not herein delegated, meaning all powers not in here granted or get permission given to these three branches of government, remain with the people. This language removes all doubt that powers other than those specified in the Bill of Rights were retained by the people, and any statute enacted in violation of such rights is a clear invalid. Is as clearly invalid as though the same had been expressly forbidden by the fundamental law. The right of the majority. See that word right there? Majority. That right there tells me that that is a democracy. It don't say it, but that's what it means to me. And I'm going to read it to you. The right of the majority to govern is as much reserved to the people as though such right had been in apt language expressed in the Constitution. That is a democracy. That is a democracy. The important question, therefore, is whether the right of the people of municipal corporations to choose their own local officers is one of the powers retained by the people which the legislature cannot take away. An examination of various provisions of our Constitution fails to show that the right is conferred upon the legislature or any other department of state government in direct, explicit, and plain language, or impliedly. to deprive municipal corporations of the power to govern themselves by officers of their own selection. If you want to create your own unincorporated private town, you can do that. On the contrary, it is very evident that the Constitution was framed upon the theory of local self-government, the right of the people to determine in and for themselves who shall be their officers. It has provided that the state and county officers shall be chosen by the people, and the legislature in this state, prior to the adoption of the Constitution, has invariably recognized the principle of local self-government. The several charters of cities and towns existing when the present Constitution was adopted provided for the selection of municipal officers by the citizens of the municipalities. They had a right to do that, y'all. Imagine somebody coming onto your private property telling you what to do, telling you you can't do this and you can't do that. These people back then, they owned that land. Not all the people back then, but I'm sure the people that were necessary who had legal title to the land in order for them to incorporate a municipal corporation, they owned that land. They had every right to do that. Let me go back to this chat and see what's going on. Gary, I got it. I have an emergency now. My stuff is complicated. I don't know why the line's saying busy, because I don't know. Y'all make sure y'all hit that like button, turn that notification, hit the like button, and go ahead and sign up for that jury members. It's $1.99. Where is it at? Where is that case? I think this is it. Look at all these cases holding this, y'all. These cases so old. We find this discussion in the right of local self-government under our form of government. That supreme power is vested in and exercised by the majority. See this? When they say local government, under the form of government that the supreme power is vested in and exercised by a majority. That is a democracy. That is a city. That is a town. That is a municipal corporation. I'm going to keep saying this because I'm not sure if y'all are getting this. When you move to a municipality, all right, you are moving out of the republic into a democracy. And the people who created that democracy long ago, maybe 100 to 300 years ago, at that time, everything they did, unless the case holds otherwise, was lawful. They had a right to do that. They were not forced to do that. And for all practical purposes, the majority are the people. See that? The principle that the majority shall govern lies at the very basis of our government. Among the rights of the majority, as part of its sovereign power, it is the right to select officers either directly by election or indirectly by authorities or officers whom they have chosen by election. This power of the majority to govern, the legislature cannot take from them. So, y'all, they tried to take your authority away from you a long time ago to vote for your local judges and prosecutors and mayors and city council members. They try to take that authority from you. This is crazy, man. Let me see. It is their. I'm gonna read this part, and then that's gonna be it. I'm gonna read another case next. It is their agent for that purpose, but it cannot limit or surrender any of the power or authority of its principles. But it may be said the legislature is composed of representatives of the people, and that therefore their acts are presumed to be the acts of the majority of the people. And that while this act deprives the majority of the people in one locality of their power, still It is in accordance with the will of the majority of the people of the whole state. That is a democracy. A republic respects private rights, your individuality to be you and do what you want to do. You don't have to participate in that. You can voluntarily participate in that if you want to, or you can leave. And that thereby the principle of majority government is recognized. There would be force in that suggestion if it was not for another principle of our government recognized by our Constitution, and if the people had not, by the Constitution, limited their power to override the will of a majority in any locality. The principle I refer to is the principle of local self-government. All right, let me see if I got any questions. See, try to call in, busy. All right, where is this? There's another case I wanted to read to y'all. Is that it? I don't think that's it. That's not it either. Is that it? That's not it. That's not it. Where is it at? That's not it. That's not. Is that not it either? I think I might have deleted the case. Did I delete that case? Kansas, Georgia. I think I might have. How did I delete that case? Let me see if I deleted it. Give me a second, y'all. I'm gonna take it off screen share. Let me see if I can find that case. It's our fault, y'all. It's our fault that you don't. It's your fault that you don't know your rights. There is no excuse that you should not know your rights when you have all of these Supreme Court cases from over 100 to 300 years ago, clearly declaring your rights, clearly telling you what these municipal corporations cannot do. If you are in a municipal court, if you are in a municipal, if you live in a municipality and that municipality is incorporated, because they do have unincorporated municipalities, then you are within the corporate territorial jurisdiction of that municipality. That you are dealing with a territorial government, just like how the United States, how Congress, what they call it, what is it, Puerto Rico, Guam, Virgin Islands, and stuff like that. You're dealing with a territorial legislature. That is a territorial government. That is how they can tax you. They cannot tax any property outside their corporate territorial jurisdiction. Where is that case at, man? I, I think it's this case. Yes, it's this one right here. Okay. Let's make it bigger. Well, that's too big. All right. I'm gonna read a few pages from out of here. All right. Let me go back to screen share because I want y'all to see this. All right. Where is it? Oh, right here. All right. Dang it. I lost the case. Okay, there it is right there. All right. So let's go back up. All right. Show y'all how old this case is. 1884. This is out of, I think, Indiana. Let me see. Yeah, Indiana, 1884. All right. There's no excuse for you not to know this. You need to go to the law library. Well, not the law library. You can go online and find this case and read it, because this is a guy. He's trying to oust these people from exercising corporate territorial jurisdiction over his private property. All right. Because if I'm not mistaken, he's paying his taxes, but taxes are conditioned on a benefit. If you're not giving me the benefit, then why am I paying the tax? That's unjust enrichment. That's inequitable. You need to give me that back, and you need to stop exercising your corporate territorial jurisdiction over my property. So let's go. Let's see. It is not necessary to set forth with much particularity the allegations of the complaint of the appellant, for no attack is made upon it in any form. The several paragraphs of the pleadings are, in all essential particulars, substantially alike, and count upon the same cause of action, which shortly stated is this: the appealee attempted to annex the appellant's land, meaning they attempted to seize his land and that of other persons. The proceedings were absolutely void, but notwithstanding the fact that such proceedings were void, the municipal officers did levy and collect taxes from the appealee, and now retains the money so collected. Although the land was not subject to taxation, you can't tax private property that is not within your corporate territorial jurisdiction. They can't do that. Even if I don't care if it looks like it is there, this corporate territorial jurisdiction, you can't see it, y'all. It's like it's abstract. You can't see it. All right. The notion is by a property owner who has paid the taxes, which he seeks to recover, and is not in action by let me see, and is not in action by a purchaser at a tax sale, so that the case is fully within the rule laid down. All right. So they're saying it seems like they're going to give him his remedy. I haven't read the case all the way through yet. The second paragraph of the appellee's answer expressly admits that the land of the appellant was annexed. Okay, they stipulate that they seized this property in the manner described in his complaint. All right, so they say, okay, we agree with that. You're telling the truth. That taxes were assessed and paid as charged, and that and then seeks to avoid the effect of these admissions by these avertments. So they admitted to all of these facts, and it seems like, in my opinion, that they're going to try to say that some sort of equity doctrine has stopped him from receiving his taxes back. That during said time, after the after the annexation proceedings, and while plaintiff resided on said premises, he voted at every city election and solicited the votes from his neighbors and friends for him as a candidate for common councilman, and petitioned the common council for improvements for the 7th ward of the city of Fort Wayne. We are unable to find any principle upon which this answer can be sustained. So they don't have any principle. They don't have any remedy for these facts for the appellant. If, as the answer admits, the proceedings for the annexation were unauthorized, the city had no right. Do y'all hear this? Pay attention to this, man. If, as the answer admits, the proceedings for the annexation were not authorized, the city had no right to levy or collect taxes. And unless the appellant has done something which precludes him from asserting the invalidity of the proceedings, his property rights are not affected by them. What is if he's done something, anything that is inequitable, he can't get that money back. The fact that he voted at a municipal election cannot have the effect to preclude him from asserting that the annexation proceedings were invalid, for that fact did not deprive the city of any substantial right. He did not injure the city, nor confer upon the appellant any privilege. See, there's an exchange right there. See that? There's an exchange. In exchange for this tax, I'm going to give you something. I'm going to give you a benefit or franchise of such legal value as to preclude him from asserting the truth respecting the annexation proceedings. Nor was the privilege of standing as a candidate for a municipal office of such value to him as to compel him to silence regarding the illegality of the attempt to annex, contiguous territory. I think that's how you say it. And surely his candidacy cannot be treated as a thing of value in the municipality. The fact that he united in a petition for an improvement does not coerce him into silence, for the bare fact that he signed a petition, neither brought him a thing of legal value. See that? Now, if he got something of value in exchange, then he will be foreclosed. It seems like that's what they're saying. Nor took from the city anything of appreciable worth. These facts may be some evidence of acquiescence, but they are much too slight to build a defense of estoppel upon him. So they're saying he's not estopped from trying to oust them and from trying to get his tax money back that he paid on that land. This conclusion is so plainly correct upon general principles that it is hardly necessary to cite authorities. But there are cases fully in point against the sufficiency of the answer. What cases are we talking about? These cases right here. Even though this is an Indiana case, I want y'all to see that this is an Indiana case, but they're citing cases from Iowa. All right, because that is a principle. So it applies everywhere. Let me check this out. Let's see. Y'all go ahead. Make sure y'all sign up for my jury members. If y'all don't mind, sign up for my jury members. It's $1.99 a month. I would really appreciate it because I like to get paid for my time. I would really appreciate that. Give me a second, y'all. Let me get me something else to try. Let me check these lines. No calls yet. I'm okay right now. I almost been on here 2 hours. This time is flying by. Let me get back to this case. Much stronger than the case may be made. The answer is that of what is this? Castle Green Tap versus Black, Indiana. 5. Where the plaintiff was held, not concluded, although he voted for the tax he sought to have declared illegal. The evidence shows that the Common Council of the city passed a resolution for the annexation of contiguous territory, but it also appears that the lots which the city attempted to annex were not platted and that the appellant did not consent to the annexation. They didn't have his permission. He did not consent to that. Under our statutes, as has been repeatedly decided, the Common Council cannot annex contiguous territory unless it is laid off into lots and platted. Such indeed is the express provision of the statute. When the land is not laid off into lots, the city must secure an order from the Board of Commissioners for the annexation. That's another administrative agency. The Common Council have no jurisdiction in such cases, and an order of a court, even of the highest rank, in a case where it has no jurisdiction, is ineffective for any purpose. I agree with that. It is so plain that the Common Council cannot exercise jurisdiction in cases where it is expressly conferred upon the Board of Commissioners of the county that neither argument nor authority is needed. That's funny. The evidence does not show that the appellant ever received any substantial benefit from the annexation. He didn't receive any benefit, no substantial benefit, nor does it show that the city incurred any expense or was induced to change its position to its injury on account of the attempted annexation. If it had been shown that the appellant had received any benefit from the attempted annexation, or if it had been made to appear that the city had incurred expenses or laid out any money on the faith, what faith? Good faith. Good faith is the equitable faith, that the annexation was valid, we should have had a very different case. So I'm assuming that they're going to rule in this man's favor and order that he be reimbursed for his costs and these tax, and the city is going to incur the tax, and they're going to have to pay him back, and they're going to cease and desist exercising their corporate territorial jurisdiction over this man. I'm going to have to read the whole case. We're on page 4 right now. But we have here a case where the city did not change its position to its injury. They injured this man. They did not change. They didn't stop it. They just ignored it. Nor the citizen receive any substantial consideration. Seems like we're talking about contracts here, or something like that. They're talking about consideration. The case falls within the general rule thus stated by one of the text writers. It will be found upon an examination of the above and other cases that wherever the rights of other parties have intervened by reason of a man's conduct or acquiescence in a state of things about which he had an election and had a conduct, or and his conduct and acquiescence or even lashes was based on knowledge of the facts, he will be deemed to make an effectual election, and he would not be permitted to disturb the state of things, whatever may have been his rights at first. So you have to know what you're doing. If you don't know what you're doing, then it can't be held against you. But mere acquiescence or waiver made without consideration will not be binding if a change of purpose do not affect the rights of others. And that's the authority right there that they're citing. There may be a consideration sufficient to bind the person under a duty to act, although he receives no benefit. A consideration may exist, although the party against whom a right is urged may have received nothing of value from the other party. It is sufficient if there be loss or injury to the party acting. This principle is illustrated by the cases which hold that where a landowner licenses another to do an act and the licensee upon faith, what faith are we talking about? We're not talking about bad faith because that is inequitable. We're talking about good faith because that is equitable. This principle is illustrated by the cases which hold that where a landowner licensed to another to do an act and the licensee, upon the faith of the privilege granted, expands large sums of money, the licensor cannot revoke the license. Why can't he do that? Because that is inequitable. You can't do that. It is further illustrated in the cases of boundaries, for in such cases, long acquiescence in a line of acceptance as the boundary will preclude the real owner of the soil from reclaiming it and changing the boundary if the other party has made valuable improvements on the faith. What faith are we talking about, y'all? Good faith. Give me a second, y'all. I'll be right back. I'm gonna take it off screen share right quick, and I'll be right back. Well, no, I'll leave the screen share up, and I'll be right back. Where is it at? I'll be right back, y'all. Give me a second. What? Trying to teach. All right. Let's get this back. I got about 13 more minutes. I'm gonna wrap this on up. And I'm gonna read this again. Because y'all need to read this case. This is our fault. This is our fault. Public servants think that they can do what they want to do. It's our fault because people just let them do what they want to do. This is our fault. It is your fault that you don't know your rights. It ain't nobody else's fault except for yours. You need to read. And you need to know your rights before you need to know your rights. I'm going to read this again, then we'll go on down. It is further illustrated in cases of boundaries, for in such cases, long acquiescence, long agreement, long tacit agreement, long implicitly agreement. It doesn't matter if you say it. It doesn't matter if you expressly say it. If you say it with your actions, then that is acquiescence. Long acquiescence and a line accepted as the boundary will preclude the real owner of the soil from reclaiming it and changing the boundary if the other party has made valuable improvements on the good faith that the boundary was the true one. And there's all these cases right here. Look at this. Let's get back. I'm sorry. We got what we got. We have in an Illinois Supreme Court case, a Michigan Supreme Court case. These are, what is this? Is this Pennsylvania paints? I don't know what that is, but I'm assuming that's um I don't know what that is. But anyway, we got a California Supreme Court case. These are principles. That the reason why they're citing these cases after making that contention is because these are principles. It is true that the mistake which caused the invalidity of the annexation proceedings was one of fact, but acquiescence in a mistake and knowledge that large expenditures have been made in ignorance of the mistake may preclude a party from relief against it. The general rule, undeniably, is that a party is not estopped unless he has knowledge of all the material facts. What are material facts? Material facts are facts that cause you to do something. These are deciding facts. These facts decide a matter against you or for you. Or for you. That's what material facts are. But there are many exceptions to this rule, and they cite Pomeroy. What is Pomeroy? This right here, Pomeroy is they have a treatise on equity, because this is what we're discussing right now. We're talking about equity. Even though they haven't used the word equity in here, that is exactly what we're talking about. We're talking about equity. I know we're talking about equity because I see the words. I can see it. The rule has sometimes been stated as though it were universal that an actual knowledge of the truth is always indispensable. It is, however, subject to many restrictions and limitations as to lose its character of university, universality, or whatever. I can't even pronounce the word, y'all. I'm sorry. It applies in its full force only in cases where the conduct creating the estoppel consists of silence or acquiescence. Like in my case that I was just telling y'all about, they have a duty to respond to this. You can't just ignore these allegations unless they just patently meritless. Then yeah, you can, but I don't file meritless lawsuits. I'm not a vexatious litigant, and I don't file meritless objections. It does not apply where the party, although ignorant or mistaken as to the real facts, was in such a position that he ought to have known them, meaning that he either knew this or he should have known this, so that knowledge will be imputed upon him, or will be imputed to him. I'm sorry. In such cases, ignorance or mistake will not prevent estoppel. Nor does the rule apply to a party who has not simply acquiesced, but who has actively interfered by acts, meaning implicit, or words, meaning expression, and whose affirmative conduct has thus misled another by fraud. You fraudulently induced me into doing something. You misrepresented material facts to induce me into making a decision that I would not have made if you did not misrepresent these facts. Finally, the rule does not apply, even in cases of mere acquiescence, when the ignorance of the real facts was occasioned by culpable negligence. Pomeroy Equity Jurisprudence, Section 809, talking about equity. We think that where the question is as to the corporate boundary, and where the authorities who attempted to extend the boundaries act in a public capacity and in good faith assume to make the change in the corporate boundaries in accordance with the provisions of the law upon the subject and fail in doing so by mistaking a fact, the corporation may successfully assert the efficacy of change against a taxpayer who has lived in the territory sought to be annexed, who has for a considerable length of time acquiesced in the validity of such proceedings, and who has, without objection, seen large sums of money expended on the faith that such annexation proceedings were valid. I got to read that for y'all again. This might be going over y'all head. If you don't want these people exercising corporate territorial jurisdiction over your private property, you need to oust them. You do not need to accept anything from them. Because if you do, there's a probability, probably a high probability, that equity is going to foreclose you from doing it. You're going to be prohibited from doing it because that is inequitable, unless it's just a gift from them or something like that. So I'm going to read this one more time. We think that where the question is as to the corporate boundary and where the authorities who attempt to extend the boundaries act in a public capacity and in good faith assume to make the change in the corporate boundaries in accordance with the provisions of the law upon the subject and fail in doing so by mistaking a fact, the corporation may successfully assert the efficiency, the efficacy, I'm going to say that, of the change against the taxpayer who has lived in the territory sought to be annexed, who has for a considerable length of time acquiesced, you've agreed to this, you've accepted this, either expressly or implicitly, who has for a considerable length of time acquiescence in the validity of such proceedings, and who has without objection seen large sums of money expended on the faith that such annexation proceedings were valid. There are many reasons why different rules should apply to the acts of municipal authorities engaged in the performance of purely public duties from the one which obtains in cases where the controversy arises out of matters of private business between individual citizens. Notice that they always, when they speaking about us, they talking about, they use the word private. And when they talking about the government, they mean public, because you're not public, you're private. Let's see how much time we got on here. Got about 3 minutes on the air. I don't know. I might have gave you the wrong. Let me see. I tried calling, but the system asks for a host pan. Is there a way to compel the court to set a date for a case that was continued from last November, or is there a time limit that you know of? There, you can check. You're in federal court or state court? You're in federal court or state court? Let me go back to reading this. The municipal authorities in such a case exercise delegated governmental functions for municipal corporations or instrumentalities of government. The officers of the corporation acting in public matters represent the inhabitants of the locality. For the inhabitants of the locality and not the officers constitute the corporation. The acts of such officers are public, and one who is interested in the subject over which their acts extend is bound to take notice of their acts and proceedings as per of record. So you need to act immediately when they do something you don't like. You can't sit there and do nothing. Let me go back and check this chat. Looks like this time is almost up on the air. Let me see. Do you have any case law of evictions? Well, first off, look, I see y'all asking questions, but ain't nobody signing up for my jury membership. It's $1.99. I feel like I'm at least worth $1.99, y'all. Come on now. I feel like y'all just ignoring me, man. Y'all just ignoring me. I can come over here and do this stuff. I can have all types of cases for y'all. But I don't have the time to come up in here and research it.
90 seconds.
I have stuff to do. You know what I'm saying? I tried calling, but let me see. District, district. What do you mean? State district court or federal district court? I don't have any case law of evictions. I can find them though. I can find anything, but I don't have any right now.
60 seconds.
Blessings. Beats by Jerome. What's good? What's good? Just free game. Just go ahead and sign up for a membership. It's on the YouTube channel. It's $1.99, man. You know. But if you want, let me see the cash app if you want it. Hold on. I got a headache. State district. Okay. If you in state court, they have what they call, and I'm not saying this applies there. I don't know, but they have what they call a denial by operation of law. So a denial by operation of law is
10
essentially this:
seconds.
when you file a motion, and if the motion is pending longer than 30 days, then it's deemed denied by operation of law. So I'm not saying that that's the case here. I don't know. But if that's not the case, you have to realize that when you're dealing with these people, um, they're you're not the only one that they're dealing with. They have certain criminal cases too that they're dealing with, and criminal cases take precedence. In other words, they take priority over civil cases because you have more rights that could potentially be violated in a criminal prosecution as opposed to a civil prosecution, if that makes sense. Let me I'm gonna end that episode. I'm sorry with the number. I don't know what happened with the number. I don't know what's going on with that. I'm gonna take it off screen share. If y'all want that case that I was just reading, let me know, and I'll send it. I'll give it to you in the chat. Free game. Oh, I answered that question. Yeah, cash app. Appreciate the cash app too. Free game. Appreciate it. Y'all. I'm not asking for much. You know, I know we got bills to pay. Trust me, I know. That's why I don't ask for much. That's why I made the cheapest thing on my channel is for $1.99, and I know I'm worth that. Y'all don't disrespect me and y'all don't think I'm worth $1.99. Come on, man. Thank you. That helps with stuff. I filed with no response. I mean that's it's a possibility, SG. If you don't mind, man, sign up for my jury members, SG. It's $1.99, man. It's gonna cost you what, $24 a year or something like that? Oh man, I thought you were asking about the case. I didn't know, man. I'm sorry. I thought you were asking about the case. I don't know where it's at, man. I'm gonna see if I can screen share and show it to y'all, man. 'Cause I don't know where it's at. Give me a second. Let me see if I can screen share and show it to you. That's okay, right here. All right, I'm gonna screen share it, y'all. All right. Okay, so you go right here to join. Go on here and you click. Oh, I thought it was $1.99. It's 99 cents, y'all. I thought it was $1.99, but it's 99 cents. I should have at least. I have like how many subscribers I got? I think I got 1,900. Well, a little over 1,900 subscribers. I'm almost at 200. I mean, 2,000. So I should have at least. I mean, 30%. I mean, it's only $1. Forget that. If it's only $1, I should have 1,900 subscribers. It's $1, y'all. Come on, man. It's $1. I know I'm worth $1, y'all. Come on now. Let me get back on here and read the chat right quick. I'm gonna take it off screen share. All right. Let's get back to the chat. Let's go back. All right, sorry about that. Does YouTube get a cut? Yeah, yeah, they get a cut. They get a cut, SG. I think they get I think it's 70% that they get. Not I'm sorry, not 70%. They get 30%. I'm sorry. Yeah, YouTube gets 30% if I'm not mistaken. They get 30%. Um, how long has the I don't know. I'm sorry about the phone lines, y'all. My bad, SG. I don't know what happened. But so you need to you probably need to read some cases or read some statutes or something like that, SG, because they might do that everywhere. I don't know. I know in some cases they do it here, or it's probably just in an administrative court, even though all of them are administrative courts. So that's probably where they do it. I know in some courts they do it down here. Yeah, I do consulting. Excuse me. Yeah, I do consulting free game from time to time. Yeah, I assist with all types of stuff. I'm not gonna sit here and tell you that I know everything because I don't have all of the answers to your questions. But if you have a question for me and I don't know the answer, I'm 100% certain I can get you the answer. Might take me a little time, but I can get you the answer. I can find anything. And I can litigate, I'm not even joking. I can litigate any case because it's all the same thing. The problem with it is I would have to study the that particular area of so-called law to make sure that I have that I have an understanding of what your rights are and how to argue the case. But I can do anything. All of this stuff is the same. It's all the same thing. What all have you filed and you didn't get a response, SG? Thank you, free game. I got your cash app. I really appreciate it, man. Thank you. I really appreciate it, man. Thank you. Really appreciate it. I think he said something about evictions. Okay, I'm gonna give you some game, free game. Um, if I'm assuming that you are in, don't take this the wrong way, but I'm assuming because a lot of us do, but we don't figure this stuff out until um these people start causing us problems. But I'm assuming that you live in some sort of municipal corporation. You live somewhere within a territory, okay? In other words, where a government is exercising territorial jurisdiction. So if you are, that is a democracy. Your rights are going to be a lot more protected there, in my opinion, because there's going to be some sort of statute, some sort of act that affords you due process because private individuals they don't have to give you due process at all because the Constitution doesn't apply to them. But if there's somebody that has came over within that corporate territorial jurisdiction and they own houses over there, um, the legislature, in my opinion, is going to require them to to do to afford you some due process, like some type of notice or something like that, um, prior to you getting evicted. So you need to check that out. Check out all your eviction law. Read not laws, but read all the statutes over there, because your rights are going to be uh, in the statutes, not just the statutes either, but read cases too, because that's where your rights are going to be. They're going to be within these statutes and the cases. If you don't see your right in a statute, then it's probably in a case, because what they do a lot of times is when they get cases, they codify principles. In other words, they bring them from common law jurisdiction and they codify them and they bring them over into their jurisdiction. So they adopt common law rules, if that makes sense. Motion for summary judgment as well. Um, okay. If you're following all, I'm not saying you're not. I don't know, SG, but if you're following all the rules, um, I don't know why they're giving you a hard time unless you suing somebody that's in the government. They're gonna give you, in my opinion, they're gonna give you a hard time for that because you just, I don't know what's with these people. Y'all get back, get back, get back. I told you about that. Give me a second, y'all. I'll be right back. Don't you come over there while I'm live. And one piece is open. What? Oh, you don't know. All right, sorry about that, y'all. I'm trying to live stream and I'm on duty. I got people over here. Let me see, child support agency. Okay, that's controversial. In my opinion, that's controversial. SG. You look, in my opinion, no attorney is going to argue a case that is against the status quo. You can forget about that. They're not gonna do that. If your arguments, I don't care if your arguments have merit, you can be 100% right. If it goes against the status quo, they are not going to adjudicate that on the public record. I don't know what's wrong. I don't know why they do that. All right, but I'm guessing they don't want people to know what's going on. I think I have to give a list of exhibits for judge and never did for summary judgment. Oh yeah, you got to do that for summary judgment. Yes, you do. You have to. That's why I've never done a motion for summary judgment, but I know how long it is, and even though I never done one, I hate it. But yeah, when you so summary judgment, you do summary judgment after discovery has ended. So what you're doing is you're saying, Your Honor, we don't need a jury. I have all the evidence, and I think that this evidence will be material. Let me rephrase it. I think this evidence is material in deciding this case. So I don't need a jury. So what I'm going to do is I'm going to file a motion for summary judgment because there's no genuine issue of material facts and disputes. And I am entitled to this judgment as a matter of law based on these facts and based on this case law. And when you do that, you have to say on such and such date, this happened. Then what you do is you cite the exhibit in support of why you're saying what you said. You have to be very detailed in motion for summary judgment. Even though I've seen some attorneys' paperwork, um, I mean, they're not as detailed, but they're detailed. Some of their work is sloppy. Some of it looks good, but some of it's sloppy. Thank you to everybody that's joining. I really appreciate that. I really do. Thank you. If you're watching, please go ahead and sign up for jury members. It's 99 cents. I at least know I know I'm worth $1, y'all. Come on now. Let's see. Child support agency. Never did for summary judgment. Yeah, you got to do that, SG, because what? Okay, the problem is, SG, what facts are you giving the judge to look at and verify in support of your motion for summary judgment? They're not going to do your work for you. You have to give them. You have to make your arguments, cite your cases, and cite the facts in support of your cases, and cite the evidence in support of your cases and facts. That's what you have to do. You have to tell them where they go. Let me see. I could tell at one point the judge said we may have some new case law on our hands to the child support attorney in the last hearing. I don't know. Okay, so uh, you must have that ebook that I was reading in regards to the child support, SG, and so you must be raising some of those arguments. Thank you to everybody that's joining jury members. I really appreciate it. Thank you. Thank you, Sour Seeds. Um, I don't know who this is. Who is this? I don't know his name. I'm sorry. It just says member. I don't have your name on here, so I can't shout you out, but I really appreciate it. Um, 'Cause- 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 Let's see. It was in the motion, but there is some kind of notice of exhibits that is to be given to the clerk. Okay, so that may be some sort of local rule or something like that. That rule may not even be in the rules of civil procedure where you are. It may just be a local rule. You know what I'm saying? You know how when you were litigating in federal court and they have their own local rules, how they want stuff done in their court. They do that sometimes in state court too. It was a due process issue. I told you, man. I don't even remember as you've been. I'm sorry, man. I don't remember, man. I'm sorry. I wanna I think I'm gonna go on my YouTube channel and I'm gonna read y'all some of these comments. Let me see. They took money without allowing me the chance to appeal according to state law. Um. Oh, I think this was a. You said this was a due process issue, so I'm assuming that they never served you service. In other words, they never perfected service of process against you, and since they never did that, they never obtain in personam jurisdiction over you. And when they do that, they issue an order in a manner that's inconsistent with due process. And as a matter of law, that order is patently void when they do that. I think that's what you're talking about. Oh, okay. Appreciate that, Albert. I really appreciate that, man. I really do. I really, really do. Um, let's see. They took money without allowing me the chance to appeal according to state law. You might have to take them. You might have to appeal it. But again, let me. I gotta stress this to y'all, man. When you filing lawsuits against these people, when you're litigating cases pro se, this is just my own personal opinion, okay? Yours may be different, but in my own personal opinion, these people are haters. They just hate. All right. So when you file an appeal pro se, you asking the appellate court to say you who've never went to law school a day in your life that this judge who's went to law school, who's been a judge for I don't know how long, is wrong. It's like they have ego problems, man. Like they just, I don't know what it is, man. I don't know. I don't know what it is. You know you may win. You know I don't know, but I know the case that I'm litigating in federal court that I'm assisting with litigating in federal court. That case should have not been dismissed. There were a few causes of actions that should have been dismissed. I agree with that, but that whole complaint should not have been dismissed. He never really even mentioned how the complaint we had was probably about 15 pages or something like that. He never really talked about anything in the complaint. He didn't address any of the objections at all. He just ignored everything. So now I think this is going to be difficult. I could be wrong, but I think this is going to be difficult because we have to appeal this case and we have to get the appellate court to agree with us that their colleague is wrong and we are right. And we ain't never went to law school. I don't think people understand how serious that is to them. Because I promise you, you do not need to go to law school. The only thing that in my opinion, the thing that people need to practice on in court is objections. That's it. Because drafting paperwork and reading cases that's the easiest thing I've ever done. And finding cases, all of that stuff is easy. Let me see. They skipped steps and said I waived the right to notice when I didn't waive the right to the notice that explained the rights to appeal for mistakes of fact. I could be wrong, but the attorney seemed to be turning her nose up at me. I got a child support case by way of paternity acknowledgement. Where is a good place to begin this process of getting out of this? How old is it, Albert? And did you send me an email requesting any of the child support books, the material stuff like that? Did you send me an email requesting that? You don't have a government, y'all. You do not have a government. They're corporations and they private contractors, in my opinion. So it's these man, they hard to deal with, y'all. They hard to deal with. They hard to deal with because these are the people that you go to when your rights are violated. But they violate your rights. I did, and I have the PDF. Okay. How old? Okay. When did this happen in regards to you being adjudicated the father? We said, let me see, by way of paternity acknowledgement. Okay, so you acknowledge that you were the father. Okay, been going on 15 years. Dang, that's a long time. They did violate your due process rights though, because they violated your fundamental right as a parent. What's going on here is essentially is they're infringing on your right for you to exercise your discretion to determine how much support that you reasonably believe is necessary to take care of your kid. That's essentially what they took from you. They don't want to tell people this stuff. They want to give you visitation. Yeah, that's what they do. Um, I'm about 99% sure that your remedy is in equity. As a matter of fact, it's in that book. You're probably not going to be able to see it because if you're new to this, it's going to be a little difficult for you to see. But your remedy is in equity. That's where your remedy is. I would have to go on. Let me how much time we got? Let me see. I'll stay on for about 20 more minutes and then I'll leave, y'all. Spend more time and money with your kids. Document it. Yeah, I've been in and out of jail all this time and been filing motions ever since I found out. They gon' they, they're never gonna tell you if you're right. All right. But when you're wrong, they'll tell you when you're wrong. They might not do it when they want to. I mean, when you want them to, but they'll tell you when you're wrong. But if you're right, they're not gonna tell you you're right because you're not an attorney. You're not supposed to know this stuff. They're not gonna tell you you're right. They're gonna have you thinking, well, I did this. This must not be the right information. I must have did something wrong. You know what I'm saying? They'll have you just guessing, and the whole time you ain't do nothing wrong. They just dishonorable. They're not honorable men and women. This is all about money, man. I'm gonna screen share and I'm gonna pull up this document. I'm gonna show you something. Albert, give me a second. It's in, I think it's in the Treaties of Rose. Is that it? Is that it? Let's go here. Okay. All right. I'm about to screen share right now. Give me a second. All right. Albert, the document that you're looking at is in the Treaties of Rose. It's in this PDF book. Let me show it to you. What page? This is page 34. All right, so let me go back up. See this, the Treaties of Rose? This document is in, matter of fact, I got something even better for you. Give me a second. Let's go to, here we go right here. And I'm going to show you the case. This guy right here, this man knows what he's doing. He's challenging child support for a lot of people because he said they are unlawfully enforcing child support against people, and they are based on what I've read. What is this? Honor versus Kemp, Honor versus Georgia. I think it's this one. Let me read y'all something. Georgia father challenges the constitutionality of Georgia's custody laws. Whatever deprives the parent of the right to the custody and services of the child without fault on his part relieves him from the duty to support the child. 1927, Georgia. How a Georgia man case may change this nation's conversation on how we discuss child support and custody laws for all parents. So, okay, this is his complaint right here. All of this stuff is free. This is his website right here. All of this stuff is free. All right. A motion for declaratory judgment. State of Georgia's answer. Motion to deem request for admissions admitted because they don't want to answer. Listen, man, I gotta say this because I'm glad this is here. When your complaint is good, all right, they gonna drag their feet. You might not never get an answer from them, or if you do get an answer from them, it's not gonna make any sense. That's what they call a shotgun pleading. It's gonna be all over the place. You know how when somebody shoots a shotgun and the shells go everywhere, they're gonna violate the pleading rules. They're going to confuse you. That's what they did in my case. But let's go to. I want to go to the complaint. Motion for declaratory judgment. Where is this complaint at? The court filings and there might be. Let me see. I think this is the complaint right here. This is a 50-page complaint. Let me see if I can pull this up. I think this is it. Let me see if I believe this is it. But let me see. Yep, this is the complaint. Okay, this is the complaint right here. I'm gonna read some of it. All right. Preliminary statement. This is a constitutional challenge to Georgia's presumptive and best interest of the child statute. All right, I'm gonna stop right there. See what what they have done was they have replaced the strict scrutiny standard with best interest standard. Anytime you have a fundamental right, the state has to prove that they have a compelling public interest to be interfering with your private right. All right. On this standard, the best interest standard, they don't have to do that. They displaced your standard to make it easier for them to come in and infringe on your fundamental right to the care, custody, and support of your child. That is what they did. That's exactly what they did. Georgia has abandoned a practice that long protected the right to the services and custody of children in the custody disputes between. Let me make this a little bigger. Disputes between two parents by clear and convincing evidence. The current law and the application of Georgia's statutory scheme do not constitutionally protect the fundamental custodial rights nor property rights of the parents in their children, which has been the result of continued and ongoing ordered subordination and the arbitrary infringement of rights by the state's unnecessary exercise of parents' betrayal. He is 100% right. He 100% right. Parents, the state is acting as the parent. They're usurping their authority over you against the child's best interests. Plaintiffs bring this action invoking Georgia's constitutional protections to their interests. Did he say plaintiffs? Oh, this must be a class action. He said plaintiffs. Okay, so there's two of them. Okay. Plaintiffs, by the way, this is a pro se litigant that did this, y'all. This is not an attorney. This is a pro se litigant. This case is extremely controversial. And you crazy if you think that they're going to adjudicate something this controversial by a pro se litigant on the public record and tell this man that he right. You out your minds if you think that that's going to happen. Because it ain't. Plaintiff brings this action invoking Georgia's constitutional protections to their interests and their property rights. I'm sorry, and their rights to privacy. Let me see, and their rights to property, privacy, and custody. So anytime you're dealing with family, anytime you're dealing with how you raise your kids, how you rear your kids, how you exercise your parental discretion in determining how much support, financial support that you want to, provide for your kids. That's privacy. That's privacy, and they're infringing on it. They cannot do that without a compelling public interest or your permission, and to direct the religious upbringing of their children, including the same under the U.S. Constitution and the substantial due process. Plaintiffs seek to de- plaintiffs seek a declaratory plaintiffs seek declaratory injunctive relief. So that's equity right there. See that? That is equity. They're trying to prohibit them. They're trying to stop them. They're trying to enjoin them from doing this. And there's the statute right there, as well as a permanent injunction. You see, but if through misconduct or other circumstances, it appears that the case is exceptional. Only then parents' betrayal must protect the helpless. Are your kids helpless, man? Did you abandon your kids? Did you abandon your responsibilities as a father? Or were you ousted? Or was your kid taken from you by the mother and secreted to somewhere you don't know where, and she ran down to an administrative agency and made up some lies on you and trying to get public assistance or something like that? Give me a second, y'all. I'll be right back. This was the case. This was said in a case involving a controversy over the custody of a child between its parents. 1940. Look at that. That's a Georgia Supreme Court case. This is our fault, y'all. This is our fault. It's your fault you don't know your rights. And you need to accept accountability of that and grow and learn from it. I was the same way. Let me go back to the live and see what's going on. Um, let me see. Based on minimum contacts. I think that's. I'm not saying you're right, SG, but I think that's a reasonable conclusion. I would say that that's a reasonable conclusion, because if you are outside of their corporate territorial jurisdiction, then they have no minimum contacts to exercise parents' betrayal, because the state in parents' betrayal, they're acting as the sovereign, and they're not sovereign. They don't even have any money. They bankrupt. How you gonna be sovereign and you bankrupt? Yeah, let me see. Yeah, I've had no access to or rights regarding this child. The only of my offspring, one of 7 kids, I pay support for, and the only one I have no access to. Acquiescence, I should have said. Ignorance of the law. Let me see. Kids in public. All right. Yeah, right there, SG. Those are minimum contacts, SG. You're right. Those are minimum contacts. Um, where's that document at? Did I delete it? Oh, it's right here. It's right here in my face, y'all. All right, let's go down some more. The Georgia legislature enacted Georgia House Bill 369. I almost start singing that Yee Yang Twin song. I mean, that Lil Jon song. That Get Low song. Amending Section 3 of Chapter 9 of Title 19 of the Official Code of Georgia. You're dealing with in a territorial government. They are all administrative agencies, every single one of them. Attached here too as Exhibit A, statutory best interest standard. There you go, right there. So are y'all paying attention? Are y'all paying attention? So I'm assuming what they say, the best interest standard. The Supreme Court declared a common law best interest standard. And what did Georgia do? They adopted that standard. They codified that standard into their jurisdiction. Section 3 provides, there shall be no presumption in favor of any particular form of custody, nor in favor of either parent. That is patently unlawful. You cannot do that. They just violated due process when they did that. It further provides that the judge hearing the issue of custody shall make a determination. You already have custody. Y'all share equal custody. It's 50-50. You don't need a court order for that. People need to start acting like adults because that's the problem. The judge hearing the issue of custody shall make a determination of custody of a child, and such matter shall not be decided by a jury. The duty of the judge in all such cases shall be to exercise its discretion, to look to and determine solely what is for the best interest of the child. Also also provides the best interest of the child shall apply in legitimation disputes. Plaintiffs challenge Georgia House Bill 369, amending section 3 of blah, blah, blah. I'm not going to read all that. And blah, blah, blah. Facially, this is he's challenging it. He's looking at it and just saying, he's looking at this statute and says, yep, this is patently unlawful. Just by reading it, it's unlawful. And as applied, he's saying they also are applying the statute in an unconstitutional manner, contending the current law violates the substantial due process rights of parents by lacking a favorable presumption, he's absolutely right, and the appropriate burden of proof, clear and convincing evidence, which results in an unnecessary and arbitrary exercise of parents' betrayal. He's absolutely right. Y'all need to go and read. This is my first time reading this. I've been knew about this case, but this is my first time reading this. He's right. In custody disputes between parents infringing on the rights and interests of Georgians absent the least restrictive means. Georgia's parents, fathers, and mothers alike have all been affected by the current usage of Georgia's statutory scheme by its current and continuing application of such a scheme applied solely in contested child custody disputes between two parents. What are you going to court for? Arguing over custody when you already have custody? Why on earth would you voluntarily submit to the corporate territorial jurisdiction of an administrative agency and give them the authority to adjudicate this matter for you, to decide this for you? You grown. What is wrong with boy? Whew. Let me go back to this, man. With respect to fathers, however, a recent study done by the Custody Exchange, a parenting plan software for separated parents, found that Georgia fathers get less than 24% of parenting time with their child. Georgia shockingly ranked number 46 out of 50 states. Footnote 3. There's the footnote right there. So if you click on footnote 3, there's the information that he's talking about. In any event, any parent with less parenting time with his child is substantially more time. Hold on, let me go back. In any event, any parent with less parenting time with his child is substantially more times than, as minimally often, the non-custodial parent, the parent who has lost their rights. He's right, to physical custody, including have had their right to the services of their child removed. He's absolutely right. That is a fundamental right here. Their right to the services of their child. That is a fundamental right. That is an inherent right. It's not a statutory right. It's not a civil right. It is not a right that can be given to you by the government. He's absolutely right. A substantial right, let me say, a substantial body of empirical research examined the implications of a father's absence on a child's well-being. Georgia psychologists have found that young boys who are deprived of their fathers often turn to other juveniles with comparable developments and engage in felonious descent to a civilized society in a subconscious cry for help, and most often turn to street gangs. Lord, he ain't lying, because I'm a East Side Rolling 20s crip. And he not lying. My father was not in my life like that. I was raised by my mother majority of the time. He ain't lying. Additional studies have shown that greater exposure to father absence was strongly associated with an elevated risk for early sexual activity and adolescent pregnancy. With respect to both parents, mental health professions has stated that Georgia's statutory scheme as it stands pits both mother and father against each other, which results in a immeasurable amount of harm done to the family unit that non-custodial parents and children are forced to disconnect with one another for their own emotional well-being. Good God. I can't read all this tonight, y'all. But y'all need to go and read this. This man know what he talking about, man. I haven't even got to the facts of the complaint yet. He know what he talking about. Y'all need to go and read this. I got to I gotta get off here, man. I'm tired, y'all. I gotta get off here. Before I go, I'm gonna say it once again. If you haven't already, please sign up for my juror membership. It's 99 cents. I know I'm worth 99 cents. I should have at least 2,000 people sign up for that. I mean, I got almost 2,000 subscribers now. I should have at least 2,000. It's $1, y'all. Come on now. I made it $1 on purpose because I know some of us just ain't got it. Anyway, I mean, even though it's long, I think I'm gonna read this until I finish it every time I go live. That's only if y'all want me to. I'll read it and go over it if y'all want me to. But y'all need to read that, man. I got to get out of here, man. I've been on here almost 3 hours. I got a headache and I'm tired of talking. All right, y'all. That'll be it for tonight. Everybody enjoy your evening. I'm gonna get on up out of here. Supreme Litigant is out. Peace. Um, let's see. That's how we got this.